Emerging international law for migration mean for sovereignty. I leave the honor and pleasure of introducing her to one of our colleagues and also a colleague of Chantal in the law school, Professor Aziz. But before I give you the platform when we start the introduction, I would like just to alert you to several talks in our series. The next one is by Françoise Burgess. If you have the chances to pick up one of these flyers, it would be great. It was Françoise Burgess, who's a theorist from France, and the lecture is Mutilated Geography, and it is Tuesday, October 29th, which will be followed the next day by a film on the Martinican writer Maryse Condé, and it's a film, and there will be a panel, and she'll be joined by several colleagues from Cornell here on a discussion after the film itself. And that should set it for our fall series, but we do have a very rich also scheduled in the spring at a conference too. So please join in welcoming Aziz, who will be introducing Chantal Thomas. Go ahead.
It really is my pleasure and honor to introduce Chantal, who's a colleague and friend from the law school, and it's been one of the highlights of my time here at Cornell so far, getting the chance to get to know her. So Professor Thomas is a professor of law at Cornell, where she also directs the Clark Initiative for Law and Development in the Middle East and North Africa. She teaches law and development as well as international economic law. Prior to joining Cornell, she was the chair of the law department at the American University in Cairo. She also was on faculty at the University of Minnesota and Fordham University law faculty. She's been a visiting professor at various places, including the Center for Transnational Legal Studies in London and Suzhou University in China. She's consulted for USAID, the Bureau for Democracy, Conflict, and Humanitarian Affairs. She's currently on the Executive Council for the American Society of International Law and the U.S. State Department's Advisory Committee on International Law. Her scholarship focuses especially on issues of law, political economy, and global social justice. She's published extensively, so she's the co-author of a book with Joel Trackman called Developing Countries in the WTO Legal System that came out from Oxford University Press in 2009. One of the pieces that I would especially point you to is Law and Neoclassical Economic Development Toward an Institutionalist Critique of Institutionalism that came out from Cornell's Law Review in 2011. She's going to be presenting from her new project, which is very exciting, and that the title for one of the pieces that's part of the sort of an extended series of arguments is What Does the Emerging International Law of Migration Mean for Sovereignty? Welcome, Chantal.
To see you, so many friends that have come out, so I really appreciate it, and it's just such a pleasure to be invited. So thanks to the Institute for Comparative Modernities and to Salah Hassan for making this possible, and thank you so much, Aziz, for welcoming me. I would say back at you, simply. Mutual Admiration Society. So yeah, I'm really excited to present to you an aspect of this larger project on what does the international law of migration mean for sovereignty. So I'm going to be balancing my laptops here. I hope this works out. But the topic is the relationship between the international law of migration and another international legal concept of sovereignty. And there are kind of multiple dimensions of the project, and I'm just very excited to present some of these ideas to you today and look forward to any comments or questions or thoughts or criticisms that you might have. So what do I mean by the international law of migration? Hello, hi. It's an emerging set of rules from treaties on human rights, trade, labor, and crime. And my goal in the larger project is to examine how this emerging law interacts with background conditions of global economic inequality and instability, and how those dynamics are mediated by the conception of sovereignty. And my thesis is that against folks who are predicting the kind of dissolution of sovereignty or the withering away of the state in an era of globalization, I want to say not so fast. I think that globalization is nothing new, and sovereignty and globalization have interacted from the beginnings of the modern age. The shape of that interaction has changed over time. My background is in international economic law, but as I kind of got deeper into this project, I started to get more interested in, as well, kind of other discourses and representations of migration, and partially because I thought that I started to feel that some aspects of these other discourses kind of better account for the full significance of the issue of migration in the era of globalization. And especially I started to be attracted to these sort of artistic representations of migration, some of which I got to learn about through hanging around the ICM folks. So thank you guys for references here. You'll recognize some of these images. But maybe I'll just kind of go around and say a little bit about these images. So how's this doing? Yeah, okay. And can you guys hear me? I was told that the mic's not working, so. The top left-hand corner, it's a photograph called Seeking Refuge by an artist called Bernice Searle, and she's based in South Africa. And so this is an image that's evoking the refugee, or the process of seeking asylum. So this is one category of international migration law, and this is a form of migration that scholars would describe as irregular migration because it involves people presenting themselves at borders without the proper documentation or authorization to enter, but making a claim under international law. So in going down kind of counterclockwise to the bottom left-hand corner is another category within this rubric of irregular migration, which is labor migration. So here, this is an image by the artist Artemio Rodriguez, and he's depicting a person who's crossing the desert, presumably from Mexico into the United States, and the logo underneath says, "Going to where globalization takes jobs." Mm-hmm. So he's looking for work, for opportunity, and he's thinking of a loved one back home. And this would be another form of what scholars deem irregular migration, in that this is a person who also doesn't have proper documentation, is trying to enter the border, but now for economic reasons. And one of the points that is being made by the literature on migration today is that although we often hold these categories of political and economic migration as distinct, that it makes more sense to think of them as actually some fluidly interconnected in many cases, because in many cases the same conditions that breed sort of economic desperation and political conflict are intertwined, and it can be hard to disentangle them. And so one of the observations with respect to international migration law is that if that's the case, then the legal distinction between an asylum seeker who gets some rights under international refugee law and a labor migrant who's essentially excluded with some minimal protections under human rights law, especially related to deportation, that distinction is potentially arbitrary, and that would be a problem if you're thinking about kind of larger justice claims, right? That's also signified, I think, by the middle image, which is the cover of a graphic novel called Untitled Chapter. It's about a guy who is from French West Africa, so I think he's from Mali, and he's in the northern Moroccan town of Tangier, and he's trying to get across the Mediterranean into Europe. So the boat on the right-hand corner, a sort of flimsy boat crossing the Mediterranean, is another image from that novel, and that again would express this kind of fluidity of categories between economic and political irregular migration, in that many of the people who were in this boat are trying to leave countries that are both desperately poor and politically very turbulent. So again, the problem of categories coming up there. So these are driving factors of migration, kind of economic and political reasons. But another dynamic, I think, that describes some international migration is also the fact that some of these territories are historically ones in which there's been a lot of trade and migration for millennia that well predate the establishment of national territorial boundaries. So that's the last image here, which is a still from a series of videos made by this artist, Bushra Khalili. She calls the series Mapping Journey. And it's just very simple. It's just images of people who are based in northern Africa who are describing their efforts to cross borders across the Mediterranean into Europe. And so obviously the Mediterranean itself was a site of, historically of culture and society for, going back into antiquity. The northern and southern borders of it, or shores of it, were related by many trade and cultural connections well before the era of the modern nation state. So all of these different representations, I think, show how the migrant embodies multiple paradoxes of a moment of globalization in a world that is legally and often also politically still defined by national territorial boundaries. So one of my arguments is that I think that the figure of the migrant particularly sharply embodies these paradoxes of modernity. The migrant sociologically signifies what is both present and distant. So as a stranger, the migrant signifies the union of, as Simmel called it in his essay on the stranger, the union of closeness and remoteness involved in every human relationship. So that the other who's close by is also remote, but his strangeness means that although he's remote, he's also near. And that strangeness is actually indicated by the very term legally describing the migrant in both of the official languages of international law. So in English, we use the term aliens. So the International Law Commission talks about the rights of aliens. And in French, it's l'étranger. So literally, the stranger is synonymous to mean both the stranger as we would translate it into English and actually the migrant. So the rights of the alien are translated in French as les droits de l'étranger. So this feature of otherness performs a necessary role in helping to demarcate, obviously, the boundaries of the national social body. So in order to gain value in membership in a membership society, the presence of non-members is necessary. So in this way, precisely by being marginal, the migrant underscores or shores up the value of national political communities, but at the same time is performing the dynamic of globalization. So the dislocations, the rapid social transformations and disorientations that are associated with modernization and globalization are physically performed by the migrant crossing borders. So legally, politically, socially, conceptually, the migrant is embodying these paradoxes. And that paradox perhaps most starkly expressed by the classic writing of Hannah Arendt at the end of World War II in The Origins on Totalitarianism, where she talks about the paradox arising from the fact that at the very moment that universal human rights were established through the Declaration of the Rights of Man, that the concept of popular will and popular sovereignty will simultaneously establish. So she writes that no sooner did man appear as an fully emancipated human being then he disappeared right back into the people. And from then on, the rights of man were guaranteed by states, so that actually this emancipated human, it exists nowhere, only exists in concrete form within bounded political communities. And this was not just an abstract observation, right? Obviously, so Hannah Arendt was talking about the millions of people who became stateless over the course of World War II, who had no recourse under international law, the most vulnerable people who needed protection by human rights, who were not afforded protection because it was precisely the states who were the guarantors of those rights that had expelled them. So these are all sort of paradoxes within international law, within politics, within culture. I mean, I'll back up a little bit and talk about what was my initial interest in this topic, and it was really from the economic side. So I'm a scholar of international trade law, and working on international trade law, I began to notice that over the course of the kind of high era of neoliberal economic globalization that happened in sort of the 1980s and 1990s into the 2000s, that this was an era in which there was a fairly assertive economic liberalization being articulated by various multilateral organizations. So the WTO is expanding from trading goods to look at investment and services and health and safety regulations and a lot of other things. And many other international economic organizations were expanding their reach into the policy space of individual countries. But the question of migration was left off the table. So at the same moment that globalization of other aspects of economic activity was being managed under international economic law, migration wasn't being addressed. There were reports that developing country governments tried to raise the issue, for example, in the WTO negotiations, but it just got nowhere. So there was a logic of globalization that would suggest that international law managing globalization would begin to address specifically the question of migration, but that didn't happen. So why didn't it happen? Well, there would be a couple of reasons. One is that, as I think those images suggested, that the objective of relaxing rules on migration was of much more interest to the poor countries of the world as opposed to the rich countries of the world. So here's a chart from the International Organization for Migration. And you can't see the details, that's fine. All you need to see is the difference between yellow and blue. So hopefully unless you're blind, hopefully you're not more blind people in the audience. But the point is, even if you are, the point is if you look at the differences between yellow and blue, what you'll see is that the countries of the global north are essentially high immigration receiving countries. So yellow is signifying high immigration receiving. And countries in the global south are more likely to be immigration sending countries. There's some interesting glosses on this. So there are some high income and emerging economies that are high immigration countries within the global south. So Chile in Latin America is a high income economy. The Gulf states in the Middle East are very high immigration economies. So over 70%, over 80% of some of these states are the workforce is migrant workers. Southern Africa, which is regionally integrating. Even the country of, you can't see it very well here, but country of Sudan and Libya are high immigration countries, in part reflecting asylum seekers, people fleeing countries further south, political conflict, but also looking for opportunity in the oil industry. But the larger directionality is from the global south to the global north. And so migration is of interest to developing countries. You can see that again in this chart, also from the IOM. that shows, you can see the blue lines and the pink lines. This shows the relationship between remittances of migrants and official development aid. So remittances means the money that migrants earn when they go to another country and they send it back home. So the blue line is remittances, and the pink line is official development aid. And the point being here that in all of these regions in the Global South and also the transition economies of the former Soviet bloc, that the blue line of remittances is a significant source of income, and for most of these regions, it's actually much more significant than development aid. So migration is now a very important part of the development strategy of many countries in the global north, in the global south. But that means that that the inequality between the global north and south is reflected in negotiations around relaxation of international rules on migration, or rather the incorporation of liberalizing disciplines to include issues of migration. So one reason why immigration is left off the table in international economic law is simply that the less powerful countries in the world are the ones who are interested in it. But that's not the only reason, because there are constituencies in the countries of the global north, including our country, probably many of us in this room, who would be worried about any form of economic liberalization. So there would be bases for the countries in the global north to resist or be concerned about any kind of economic liberalization. So why is the resistance so much more sticky when it comes to migration, flows of people across borders as opposed to goods or capital? And there, the answer is probably very simplistically, liberalization in flows of people across borders is just perceived as a much harder political project than goods and capital. So why is that the case? And I think that it comes back to this idea of sovereignty expressed as the principle of territorial integrity. So I think that underlying this dynamic, the idea of sovereignty as territorial control is doing a lot of work. This is because the principle of sovereignty expresses itself originally as the principle of territorial integrity. So at the very beginnings of international law, back in the 17th century, the treaties that are associated with the birth of international law, the Peace of Westphalia, they established the principle of territorial integrity or territorial control. So sovereignty and territorial control co-originate with the beginnings of modernity and international law. And I think it's for that reason that the principle is much stickier. So this idea of territorial sovereignty specifically attaching to immigration does a lot of the work, I think, to justify the relative exceptionalism for migration. In the US context, this was a principle that was memorably expressed over 100 years ago in the US Supreme Court case, Che Chan-ping versus the United States, in which the Supreme Court denied the claim of the plaintiff Che Chan-ping, who was seeking entry because of a previously issued permit. That entry was now deemed invalid because the US had just passed the Chinese Exclusion Act. And the Supreme Court held that that exclusion was valid, and in justifying that decision, the court said the jurisdiction of the nation within its own territory is necessarily exclusive and absolute. It is a part of its independence. So in other words, the court deemed that sovereignty requires absolute territorial control over immigration. Oh, one point that I want to make here, another paradox perhaps historically, is that around the same time that the US was proclaiming this importance of absolute territorial control over immigration, the pressures against that concept were increasing. So my final handy chart here is, this is a chart that shows from US immigration statistics showing the admission of immigrants, permanent residents, into the US from 1900 to 2012. And the point here is that if you look at the height of that number at the very beginning of the 20th century, that it's higher than any other point until basically the last decade of the 20th century. So right around the time that Che Jinping case was decided, there were huge numbers of immigrants coming into the US. So I make this observation in support of my kind of opening argument that the globalization is nothing new. We're in an era, we're in a moment of a particular kind of globalization, but it's by no means the first era. This, so the turn of the 19th to the 20th century represented another era of globalization with massive spikes in immigration. So what's the difference between that era and this one? Well, one, the directionality of migration has changed. So in the previous era, over 90% of the immigrants coming into the US were from Europe, only 1% from Asia, tiny fraction of 1% from China, where Che Jinping was coming from. So the directionality was from the richer countries in Europe to poorer countries in the colonies or settler states in the New World. Another difference is that the level of border control is much higher now. So in this earlier period, at least Aziz, you might have some ideas about some more information about this, but my research to date shows that passports and other border controls were not widely used until around the time of World War I, and that's when you start to get national systems of border control. And the other difference between then and now is that at that time there were very few international treaties of any kind, whereas now we have so many international agreements on many aspects, for example, of the global economy, but migration is excluded. So I think that this is showing a couple of things. One, that the background conditions of global power distribution are very much reflected in the configuration of international economic law. So I think that these observations reflect that. But secondly, that the justification for that is still provided by this concept of territorial integrity that's stemming from international legal doctrine. So the argument here is that the principle of sovereignty is obscuring and mediating the ways in which these background conditions of global inequality are continuing to shape the channels of economic liberalization and the distribution of wins and losses, of benefits and harms from those processes of liberalization. It's this principle that resolves the apparent contradiction between international law and sovereignty. So here let me consider an objection that might be raised to this account, which is that even if this is true nominally, that states remain sovereign in name, and for example, they agreed to these international economic regimes on globalization, so that these international agreements are a product of the sovereignty of states who agreed to implement them. But even if this is true legally and kind of technically and nominally, that we all know what's happening here actually the state is withering away. Actually, there is this process of globalization. And yes, migration is less incorporated into the global than other aspects, but it's just a progressionistic process, and it's the last vestige of sovereignty, but we can predict that it will eventually be incorporated into the sort of larger dynamic of globalization. So I guess this is where I want to make my kind of argument from skepticism. I think there are a couple of good reasons to be skeptical about this idea. As nice as it sounds, I mean, it sounds nice to me, but I think there are reasons to be skeptical. One is which I think it's hard to say that sovereignty is withering away when you look at border control practices and the way in which they've actually been intensified over the very same time that these other aspects of economic liberalization have been rolling out. So going back to the US-Mexico border, that border policing practices we know have mushroomed. The expenditures of the US government in border policing techniques have increased, building of barriers, deployment of drones, unmanned aerial surveillance vehicles have all increased over the same period of time. And tracking the rise in expenditures on border policing has been the increase in border crossing deaths. So the US government has issued a report showing this correlation, that in the very same time that the increase in expenditure has happened on border policing, that the rate of border crossing deaths over the last 20 years has doubled. So it's very hard to say in any concrete way that the power of the state is becoming more diffuse when it comes to immigration. It's clear that would be negated by some of these very sad statistics. But I think that there are a couple of other good reasons for being skeptical of that argument, and because I think that the idea of globalization as this sort of inevitable force overwhelming sovereignty has a way of naturalizing the arrangements that produce globalization, and so absolving our governments and ourselves from political responsibility for the consequences, for the harms and injustices that arise out of the way in which globalization is practiced. There's nothing inevitable about the specific economic arrangements that we've entered into. So in the US-Mexico context, for example, with NAFTA, there are very limited provisions made for migration of highly skilled professionals. There's no reason why those provisions couldn't have been extended to include low-skilled, so-called low-skilled laborers, of which there are many coming from Mexico to the US, and many more since NAFTA was entered into. So again, you can show statistically a correlation between increase in trade under NAFTA and increase in migration, including undocumented migration from Mexico into the US. There's no sort of reason why that would be an inevitable feature of NAFTA, of international trade law, or what have you. So I think that the idea that we don't have to worry about sovereignty because it's going away anyway is problematic analytically because it obscures these other dynamics, and frankly politically because I think that we should be paying attention to these very problematic aspects of international law. So I want to argue that sovereignty is not particularly waning, it may be fracturing or rearranging, but that it's still very much with us, and that the relationship between sovereignty and global economic forces or corporate power is, again, nothing particularly new. So we might say, well, look at multinational corporations today. You know, Walmart earns more in a year than the 30 poorest countries combined. So how can you say that sovereignty is a real force in the face of that kind of power? Today we have Walmart. In the 17th century we had the Dutch East India Company, which was also a very powerful business and was also a beneficiary of some of the arrangements that were established under international law by sovereign powers. So the founding father of international law, often described, Hugo Grotius, was also, who wrote the kind of founding treatise on international law in the 1600s, was also actually a lawyer for the Dutch East India Company, and also wrote, memos arguing for why the Dutch East India Company could do this or that thing under international law as he interpreted it. So this is nothing new. Another reason to be skeptical of this kind of progressionistic thesis that sovereignty is, withering away in some unidirectional fashion. So here, I would be skeptical of this thesis expressed in both its optimistic and its pessimistic registers. And you can find examples of both of those kinds of discourses. I call them liberal and biopolitical discourses. So within the liberal frame, you would have someone like Sheila Benhabib, who argues for cosmopolitanism. So she argues that the paradox of universal human rights but democratic nation states is resolving itself over time because we're actually moving towards a global civil society. And she makes this argument from cosmopolitanism, kind of a rarefied form of liberalism, if you like, kind of arguing from the early work of Immanuel Kant, the essay on perpetual peace, especially the law of universal hospitality. But she makes this argument that cosmopolitan liberalism allows us to think of the Earth as essentially a common construct, so that it provides a basis for resisting division into nation states, and it sort of supports what she calls democratic iterations towards this cosmopolitan future. So essentially a pessimistic, or rather an optimistic idea, right? So it might take time. There'll be some steps forward, some steps back, but we're moving towards cosmopolitanism. And on the other side of the aisle, you would have a pessimist, and here I would take as an example Giorgio Agamben, so somebody who works within kind of biopolitical discourse. He wrote this book called The State of Exception, in which he argued that the state structures are dissolving into a global martial order, and that the state of emergency is becoming the rule. So he made this argument that the defining feature of modernity was the distinction between exclusion and inclusion, or rule and emergency, what he called political inclusion or existence and bare life. He made the argument that the sort of classical example, or the quintessential example of that binary was the concentration camp, the camp in which states exercise extreme power over bare life. But one could extend, and people have extended, the Agambenian thesis to include not just concentration camps, but detention centers and refugee camps as other expressions of biopolitics, of extreme power over bare life, and of the dissolution of political order in the state into this constant state of emergency or exception, constant martial order. So, he would say also sovereignty is withering away, but it's not good. He thinks this is a terrible thing that's happening. I think that both of these have some purchase, right? So from an international lawyer's perspective, the response to this very binary kind of organization of discourse would be that rather than moving in towards cosmopolitanism, universalism, or towards martial order or constant state of emergency, that what international law provides is a framework in which there are always opportunities in either direction, as Marti Koskinen describes it, ascending and descending modes of argument from what he describes as sort of opposing poles within international legal thought and jurisprudence between apology on the one hand and utopia on the other. And that means that within any given international legal regime, on migration or anything else, we can find this interplay between these various modes of expression, the apologetic and the utopian, the biopolitical and the cosmopolitan, the assertion of territorial control, and the respect for individual human rights. So I could go into kind of specific examples, but in the interest of time, I'll just briefly allude to a few. But within all of the individual regimes on international migration law, one could see both of these ideas being expressed. So for example, the international law of against trafficking in persons provides some remedies or some protections for victims of trafficking, persons who've been trafficked across borders. There's some recognition of the human rights of victims of trafficking, some encouragement to provide them with various kinds of assistance and support. But there's also a lot of border control in the instrument on trafficking, the trafficking protocol under the UN. So there's an automatic repatriation rule that victims of trafficking, that the state of origin has to accept the trafficked person. So there's an obligatory acceptance of repatriation by the state of origin. And in the implementation of trafficking law in the US, there is a requirement that identified victims of trafficking, if they want to get out of repatriation and get a trafficking visa, a T visa, that they have to cooperate with law enforcement prosecution of the trafficker, which isn't a good thing for the victim of trafficking. It puts them in jeopardy. It potentially jeopardizes their families back home or their loved ones back home. So it's really not about helping victims of trafficking, it's about helping states crack down on borders and police borders. But so that the trafficking protocol expresses both of these ideas. And one would see examples of that looking within trade at the different treatment of different sectors of migration between high-skilled and low-skilled women, within international refugee law, in the partial recognition of asylum but the exclusion of other kinds of bids for asylum, within international human rights on the expulsion of aliens, which establishes some minimal protections for aliens who are subjected to deportation proceedings. So there are kind of minimal due process standards. There's also a right to family life. So in some cases, if you can show that would cause your family hardship, then under international law, the state shouldn't deport you. So those look like respect for individual human rights, but they're protections that are being established in service of the state expelling the person from its territory. So they're there to facilitate and kind of modulate the process of expulsion, but the process of expulsion is still very much permitted and assumed or presumed within those international legal rules. So ascending and descending modes of argument or apology and utopia. Okay, so I guess in conclusion, one question would be, if this is the way to understand the relationship between sovereignty and international law and migration, that it has within it this kind of internal contingency, this indeterminacy, then what's the argument for justice? So a critique that's often made against this kind of argument is that it's a nihilist argument because it kind of undermines any real ethical basis, because you're basically pointing out that in any given framework of relationship between rule and exception, there is some contingency, some indeterminacy, there's room for expression between very tightly structured principles that express this sort of internal ambiguity. And I guess so the kind of end of one of the aspects of the project which is, I think, not very well worked out right now, but is my effort to think about this, whether they would be, is there a way of framing an ethics that would be responsive to this more critical understanding of international law and including the international law of migration. There are many things that are attractive to me about cosmopolitanism. So, full disclosure, I'm a child of immigrants. Migration is a big part of my personal family story. I think open borders would be great. Some of you might disagree with that. We can argue about it. The kind of ethical argument for open borders is very much, I think the dominant one is the Benevibian one, which is kind of positing this cosmopolitan world order. And there are, I think, many things that are very attractive about that. But some, I think, of the most interesting writers in contemporary scholarship have pointed out limitations of the cosmopolitan frame. So among these would be Arjun Appadurai, who criticizes cosmopolitanism as being subject to what he calls trajectorism, which he says is an epistemological and ontological habit, always assuming there's a cumulative journey from here to there, or more exactly from now to then. The idea that time's arrow inevitably has a telos, and in the telos are to be found significant patterns of change and history. So there is, I think, a growing body of work that's trying to find a way to articulate a theory of justice that rejects some of the exclusionary claims of sovereignty, but also tries to avoid the epistemological limitations of cosmopolitanism, while also sharing some of its more important intuitions, but tries to find a way out of the sort of epistemic matrix of modernity, which is to say of linear and rationalistic futurism and universalism. So is there some way that we could do this in any kind of identifiable, sustainable, ethical framework? So there are a number of people who've been working on this. Bonnie Honig has proposed an alternative to Ben Habib's neo-Kantian cosmopolitanism. She calls it cosmopolitics. Ulrich Beck has identified his alternative as cosmopolitization. Rather than cosmopolitism, he focuses not on a globalizing time horizon, but rather, quote, enmeshment with the cultural other, unquote. Hart and Negri have their idea of the multitude. So they say the multitude is like the people, but, so kind of invoking the nation state, invoking democracy, but it's not like the people in that it's not formed as a unity by a hegemonic power standing above the plural social field. It's a political process, but formed through articulations on an immanent plane without hegemony. Okay, what does that mean? Well, we could talk about what that would mean, but that would be the idea. Bill Connolly has embraced a story of becoming linked to experimental intervention in a world that exceeds human powers of explanation, prediction, mastery, or control. And one of the approaches that I think is most interesting, and this is my final slide, is that of Edouard Glissant, which many of you guys here in ICM, I think, know about and educated me about. But who, yes, thank you, Salah.
No, I was saying the noise is upstairs. So
oh, okay, sorry, I thought you were saying yeah, it was me.
Sorry about the noise.
So he promotes this, so that one of the ideas coming out of the work of Glissant is this notion of creolization. So where describes, starting from one of the defining and most disruptive and in some ways most tragic forms of migration, just to say the slave trade crossings, that from there he posits a dynamic of the encounter, the interference, the shock, the disharmonies and the harmonies among cultures that produces what he calls a limitless métissage, with its elements diffracted and its consequences unforeseeable. So he is, a cultural theorist, cultural critic, but was theorizing from the experience of the slave crossing and the polyglot Caribbean experience that resulted as an alternative fundament of modernity. And what I think interests me about all of these perspectives is that I think they share what I'm calling a new organicism, in that they challenge not just linear historicism, but more fundamentally the ideal of individual autonomy that I think is at the core of the modern configuration. Individual autonomy, not just of the individual person, but of the individual nation state. And I think it's this notion of ultimate autonomy, defining both the individual and the state, that shapes the modern political imaginary. And here I'm influenced by the work of a recent work of Richard Tuck, who historically shows the way in which individual liberty and concept of sovereignty of the state within the state of nature emerged at the same time. So the idea of this new organic approach would be to shift away from this absolute concept of atomism and to embrace a reality that is radically interconnected and non-linear. And by organic, I don't mean a kind of idyllic, pastoral, new agey approach, but an interconnected reality that is highly contingent and uncertain, but defined by this feature of interconnectedness. And that's the main point of differentiation. In this world, there is no possibility of an idea of definite and impassable barriers between self and others, whether on the individual or on the national or collective levels. So these are all efforts that try to establish an ontological respect for difference in favor of an appreciation for the creative and protean possibilities of the present, as opposed to trajectorious thinking. And so here I also like Anthony Appiah's observations on cosmopolitan contamination that lead him to the conclusion cultural purity is an oxymoron. So I think this is an ethics that could potentially internalize critical understandings of law, both the internal critique of law's indeterminacy and the external critique of law's potential to cause harm. This would not posit a predetermined conceptual order, but could potentially establish a normative basis that would require that the distributive consequences and effects of law be measured. So this would be adopting a posture of organic, that is to say, inherent interconnectedness that could potentially change the starting point for the consideration of migration law and policy, among other things, and the frame for debating possibilities for reform. And that framework and the transformations potentially imminent within it might better reflect the knowledges and sensibilities of the age. Yes, thank you. Aziz, you were going to moderate. Oh, okay. Okay.
I'm curious, given your talk, about your opinions about some other speakers or thinkers on these topics,
Okay.
including a type of international law that has started looking at the right to the city, and in terms of migrants being able to vote and having urban city papers, particularly given that since 2008 the majority of human beings have been urban.
Yeah.
So you have people anywhere from David Harvey to the Fib, to Monica Bassiani, to David Rudiger,
Yeah.
all of whom could place those connections between immigration, race, racialization, and the right to the city
Yes.
together in a related literature that you did not reference.
Yeah.
I would add
Yeah.
Gilroy to that as well.
Great, yeah, thank you, that's wonderful. Yeah, I think that's a really interesting development. And there are sort of many layers of it. So one is, reframing, one major intervention that it makes is to reframe political order to reflect this completely different organization of cities as opposed to kind of nation states. So I think that's really interesting work. Within legal scholarship, there are interesting people who write about this. So Jerry Frug is one of the people writing about the global city. And also, actually in the practices of municipalities, what's interesting as well is that you are finding cities trying to, in some ways, adopt this policy where they're challenging the increasing kind of border control mentality of the states in which they exist. So this is expressed, for example, by cities who've adopted, New York is one of them. I think Oakland is another one. They've adopted these municipal ID cards that are issued to everybody in the city and don't depend on your documentary status. So it's a way for people to claim citizenship within the city, equal entitlement to all of the services and services there, and that they don't kind of expose themselves if they don't have documentation. So that, and this is a way for the city to disrupt this increasing effort by immigration authorities to come in and kind of horn in on all kinds of state and local government services to try to detect undocumented immigrants. So in this way, the city is saying, well, we don't know who's undocumented or not because everybody has the same card. Actually, the City Council of Ithaca has adopted 2 resolutions in which it encourages police enforcement not to cooperate with federal immigration authority. So there is this very interesting way in which cities, individual cities are kind of one at a time trying to challenge this larger dynamic. So I think that's really interesting. Yeah, thanks for that. And then you had your hand, and then you, and then Barry.
How much you seem to attribute to the concept of sovereignty,
Yeah.
at least the great bulk of resistance to liberalizations of borders. But I'm thinking, I could be totally wrong on this, but I was struck by your point about how small a percentage of total immigration to the United States immigration from China was at the time of the Chinese exclusion. So it's hard to imagine the Chinese Exclusion Act as being primarily motivated by concern for maintaining the sovereignty of the United States.
Yeah.
And I mean, the nation state is definitely based on a territorial and individualist logic, but it also participates in rhetorics of let me say, not race, but genos, or family. And I think control concerns about being swamped by immigration and so forth are very much tied to these.
Absolutely.
I'm not saying this is something separate from the concept of sovereignty.
No, that was the connection.
But it's not just international law is not the only source.
Well, yeah. So no, I think you're picking up on a really important point, which is that in the paper, I kind of go into this more. 2 points. I think one is that sovereignty is could be thought of as the external expression of internal political commitments to democracy or to self-determination. So kind of ideas of citizenship that would have as their internal expression a notion of establishing political community, but externally using the idea of sovereignty to defend that community. So I think that, yes, when I say sovereignty, you just translate this into a lot of political theory discourse as not between sovereignty and international law, but between liberalism and democracy. So the way that binary is expressed in a lot of sort of political philosophy is the problem of the claims that liberalism makes to universality versus the desire of any given political community that we're presuming to be democratic, so justified on the basis of democracy to defend its boundaries and to define conditions of membership. So that's one point, but the other point that you're making is that how we define the membership is, very much a feature of any number of, political dynamics, some of which we would think of as legitimate, others which we think of as very illegitimate, including xenophobia, including racism, So, I was kind of nicely describing this as background conditions of global inequality. But yes, why was it the case that the Chinese Exclusion Act was passed, even though Chinese immigrants were a tiny fraction of the total? At the time that you had millions of people coming over from Europe, right? So I don't think that's disconnected, because I think that once you understand the linkage between sovereignty and self-determination, or the right of a community to define its boundaries of membership, then you can also see that definition can take many forms. Some
It can
which
get really nasty.
are much uglier than others, absolutely. So yeah, thanks for that intervention. Thanks. Yeah.
In terms of thinking about the state disappearing or sovereignty, do you have any opinion about international law and laws that are being passed and cases that are being brought in South America, for example, Ecuador? Won a case against an oil company in the name of a river.
Yeah.
And there are also, within the constitutions of Ecuador, Bolivia, Peru's approaching that stance of giving persona to the earth, to rivers, to aspects of the environment in response to corporate power.
Yeah, that's great. I think, I think the Latin American, there's a lot of really interesting stuff happening in many of the legal systems in Latin America. I suppose you could say that, this is kind of a progressive dynamic, and if you're going to give rights to the earth, then you should definitely give rights to people who, if we're starting out from human rights, and then we're getting into the rights of non-human, inanimate, or at least
well, in their point of view, they are animate.
They may be animate, right?
Yeah,
right.
so that is the point. I was wondering what view international law would take of that stance, and they won. Ecuador won the case.
Well, I think so. I'm less of an expert on that, but I can say that on the question of migrant rights, you see similarly kind of progressive interpretations. So many of the jurisdictions in Latin America have very clearly established that an obligation of non-discrimination on the basis of everything, including documentary status. The Inter-American Human Rights Commission has reasserted that right and has criticized decisions in the U.S., for example, that, U.S. decisions that deprive certain kinds of labor law remedies to migrant workers have been criticized in the Inter-American Human Rights Commission because they violate this principle of non-discrimination. So I think that doesn't surprise me that that's a dynamic that's also happening. Also some of the regional agreements in Latin America have tried to move towards some free movement of labor, and that includes the Andean countries that were some of the ones you mentioned, but it's very much aspirational, as my understanding hasn't been implemented yet. But I think it's a good source of a kind of more progressive interpretation of some of these international legal norms. Yeah. So in order, Aziz, and then in the back, yeah.
So actually,
Oh.
I have a question about to what extent.
Oh, hi. Oh, you didn't.
Sorry, a question about to what extent international law is actually resting on territorial sovereignty idea coming from Westphalia.
Yeah.
Because now I'm thinking, and this goes back to that earlier question too, because you also have the location of a different sovereignty, like in the French Revolution, and where it's like it is transferred from the monarch to the people. Right?
Yeah.
So in the late 1800s, it comes together, the territory and nation, sovereignty is both.
Yeah.
And I say this only because of this notion that somehow international law cannot handle or is resistant, or there's a difficulty here in dealing with people as opposed to capital and goods. Right? And it's perhaps a community, it's not just about territory at all.
Yeah.
And when you think about these migrant populations,
Yeah.
you can think of them as their life. In some ways, there's a investment in not making them legible and without rights. Or
Yeah.
so I don't know.
So I agree with both those points. Another implication that I'm glad that you picked up on, but that I didn't sort of say is, and it's just because I don't know how you would prove this, but to what extent is the exclusion of migrants a kind of incidental feature of other political commitments, even if they're xenophobic ones, versus an actually very beneficial labor program, cheap labor program for various employers in receiving countries who benefit from having an extremely vulnerable population of workers. So I was just referencing this case, kind of notorious labor law case, where the Supreme Court said that a migrant worker had no remedies didn't have access to a particular remedy under national labor law because he was undocumented. And the dissent to that opinion said, you're creating conditions of impunity for employers because now they'll just fire workers who are attempting to organize or protect themselves or claim their rights, and say that it's because and the workers have no recourse. So the already very significant dynamic of pressuring of workers by employers is just exacerbated by that. So it is a question that is this a very useful, actually, from a kind of capitalist perspective, a useful arrangement, because you set up these dynamics where people are going to come,
Right.
but you maintain these legal limitations so that they aren't going to have the rights of other people. And that has the virtue of making them much more pliable, but also making the people who are, who do have legal rights, so legal residents and citizens, also more pliable because they're worried about losing their jobs to these other people. So I think, there's really something to that. And, I'd love to have a smoking gun where I could show that that's really the intention, but that is certainly one of the effects. To your other point, I also agree that, yes, it's the nation state. And so the state is sort of established in, arguably, it's attributed to the Peace of Westphalia, as people say, well, not really. Now we say it was, but it took a long time. But it's attributed to the 17th century treaties. But the addition of the nation, so it becomes the nation-state, is arguably a product of the French Revolution and the idea of popular sovereignty and self-determination, and that's where you get this way in which sovereignty is now justified as an external expression of some kind of presumably internal democratic politics. and that, by the way, opens into a whole other set of arguments about when is intervention into sovereign states justified, and there's another set of arguments that if you can show that the state is not abiding by these core principles of democratic politics, or is not accountable to its own people through kind of popular will, that its international organizations or other governments are justified in not respecting the sovereignty of those states. So I think that that connection is very active. So thanks for those points. I lost track of Barry and Aziz. And Aziz, yeah. Oh, Aziz, so Aziz and Barry and, I don't know. Natalie, yeah, I do. And Natalie, oh. I wonder.
No, I'm pointing to Aziz, actually.
So the question I had was about the organic approach that focuses on consequences on the ground.
Yeah.
And I was wondering if you could talk a little bit more about it, especially about whether or not it suggests differences in the legitimacy of claims or invocations of sovereignty. So the argument that you made seemed like a very compelling account of when the U.S. government or a country in the global north invokes its sovereignty as a way of limiting entry. I mean, there's something profoundly disingenuous about this. So that on the one hand, you have former imperial powers, contemporary global powers that are engaged extraterritorially, both economically and in terms of security policy, creating the conditions for why people show up at the door. And then, once people are there, using this very aggressive border policing, which certainly is not withering away, to essentially limit people's entry, and then create conditions where their entry is based on a flexible labor market that creates vulnerable economic populations that are unable to organize for their own rights.
Right.
So that seems to suggest that when I hear, invocations of sovereignty on the part of these states, that I should actually be deeply suspicious because this is a way of sustaining a particular set of relationships.
Yeah.
But when Ecuador makes an argument that really, another way of reading what's going on in Ecuador is that's an argument about sovereignty, about a way of controlling the conditions by which their own resources are going to be exploited and accessed, and saying that, we should be able to have the movement of people and have limitations on the movement of capital here, where it's precisely the opposite.
Right.
That's a kind of sovereignty claim
That we would want.
So I'm just curious about what this analysis in the organic approach tells us about when and under what circumstances are sovereignty claims consistent or inconsistent with the kinds of goals that would, undergird a commitment to equality.
Yeah, that's great. Also really important point. So thanks for that. I think that so I think that's right, absolutely. And it wouldn't be the organic kind of turn that would explain that, because I think that it's explained by just a kind of a legal analysis of the indeterminacy, the concept of sovereignty. So just by applying a kind of a critical legal understanding, we can arrive at the conclusion that this is a contingent concept, that it can be used in progressive ways or can be used in aggressive ways, and we would expect that to be the case with respect to any legal category. So sovereignty could be a problem. It could be a way of resisting global hegemony from the global north. So I think that's right, and that is a reason why some very dear friends of ours, who were extremely trenchant critics of international law and sovereignty, so Tony Engio would count in this group, Marty Pescaneri would be another person, are, I think, making an argument for a kind of a return to sovereignty as a way of resisting, having some basis, political basis for resisting these larger processes of domination. That it's, it might be problematic, but it's, what we have to work with. So, I think I think that I have a lot of sympathy with that. I guess I changed my mind probably over the years with respect to the sort of third worldist defense of sovereignty, for example, in the form of the claim to popular sovereignty over natural resources. I think it has many really important kind of expressions and dynamics. It has played a really important role in mobilizing social justice movements or political justice claims from the Global South. I guess I think on balance, I'm not convinced that it's worth holding on to. And so I suppose the moment when I probably really began to change my mind about this was when I was asking a colleague of mine who's an international trade lawyer who was submitting an amicus brief in an international trade dispute in which India was arguing against environmental law obligations on the basis of sovereignty, and my friend was submitting a brief to assist an Indian environmental NGO, and I made this argument, well, what, do you really want to kind of antagonize sovereignty of a developing country, given this important role that sovereignty has played in at least trying to mobilize claims to anti-hegemonic claims or anti-subordination claims. And he said, well, the people who are suffering the most from the Indian government's practices are people in India. The people who are wanting to move this claim forward are people in India. I'm not assisting, the Sierra Club sitting in Washington. I'm responding to the claims of people who are on the ground there, who are, engaged in resistance against their own government. And so, we kind of go back and forth about this, but I think that there's a lot to be said for the argument that as much as sovereignty can defend important anti-subordination practices of third world governments that are themselves being sort of constantly antagonized by governments in the global north, it also does defend them against arguments that are being mobilized from below, from the grassroots within their own countries, attempts to use international legal norms to advance justice claims domestically. And so I think for that reason, I just decided that I couldn't be a hardcore advocate for sovereignty from a kind of a third worldist perspective, even though I'm very sympathetic with the politics. So I guess that's a long way of answering the question, but I think it's an important point. But I think on balance, I'm not sure that it's worthwhile holding on to the claim. I think so. The organic, idea is an idea to kind of say, can we imagine outside of this framework in which we have this idea, this principle of sovereignty that's constantly toggling back and forth, and it's indeterminate, and the way it gets applied depends on who's doing what in what moment. Could we kind of think of an alternative to that? So, yeah. So other questions, and maybe I wonder.
Sorry. Okay. Go ahead.
Thank you for
Okay. There's a lot to say, and thank you for bringing up the trafficking piece of our conversation about that. And I'm grappling basically with some rhetorical points, perhaps. That is, you brought up at one point the question of legitimate and illegitimate discourses for removal, right? So if one just uses racist approaches, that would be, in the world opinion, pretty illegitimate. And Germany actually has been criticized by the European Human Rights Commission for some of its treatment of migrants and immigrants, second generation, and the rather cavalier dismissal of some of their group claims. Right? So that's fine, but when we come back to the Chinese exclusion, I'm wondering to what extent moral panic was part of that. The opium trade and the worries of the working class being addicted to that. And then we fast forward and look at the new rhetoric on terror, right? And the removal of hosts of communities. Men, say from Pakistan, 16 to 60-year-olds, right after 9/11, being disappeared. So that's one aspect that I want to bring. Yeah. But the moral panic, I think, is one ingredient here that shores up.
Yeah. So I mean, 9/11 created a moral panic. you know, and so a lot of the exclusionary practices, you know, that followed are influenced by that. And, what were their moral panics? You know, so-called at the beginning of the 20th century, turn to the 20th century. I think a lot of scholars have you know, pointed out that yes, there certainly were a lot of concerns about immigration from Asia, from China especially, and in some cases even also from Southern Europe, because they were like non-Protestants who, you know, drank wine instead of beer, and, you know, kind of did other things that were considered to be, you know, not what Germans would do or Anglo-Saxons. Yeah, I think there's an argument. Another piece of this is that the policing of borders against migrants is often happening at the same time that you've got policing of borders against other perceived threats, other perceived kinds of sources of economic criminality, sale of drugs, so narcotics, prostitution, you know, a bunch of other things. And these are all kind of bound up together in this sort of moral panic that has a very distinctly racist or exclusionary tone often. So early 20th century, you have the you know, international agreement against white slavery and the Mann Act in the U.S. against white slavery. You have the anti-opium you know, laws and policies that the U.S. is establishing, and you have this concern about immigration. So it's all kind of bound up together, and certainly now that's also true. So the trafficking protocol is part of the UN Convention Against Transnational Organized Crime that has protocols on migrant smuggling, and it has stuff on narcotics, and so it's binding everything up together. So does this have the effect of criminalizing whole parts of the globe? Yes, I think it does. And is that in the service of, you know, kind of maintaining status quo in the global distribution of power? Yes, I think so too. So yeah, thank you for that. And then Barry, I think, had his hand raised for a long time, and then Carol.
It might be a quick question.
Yeah.
Most of your conceptual vocabulary was at least somewhat familiar to me, with one exception. There was a pairing, not yours, you drew from a source, there was a pairing of utopia and apologetics.
Yeah.
And apologetics is not a familiar term to me in this context. Maybe it's an everyday term, and I need to do some reading, but could you talk a little bit about that term apologetics and how it functions within your presentation?
So the book From Apology to Utopia is it's an important work within international legal scholarship. So this is one of the people who adapted a critical legal analysis frame to international law, Spinelli, and another way of framing it is within international kind of affairs would be between idealism and realism. So apology is realism or realpolitik, meaning that this would be the argument from Morgenthau or going back further, Austin, that there is no real international law. It's, you know, it's not proper law properly so called. It's what happens internationally is just an effect of power, global power, and if it has the title, bears the title of international law in one particular case or another, that's just completely incidental. But it's really power, as opposed to the idealistic notion that international law really is a form of international law and it has its own kind of authority, its own legitimacy. And so, yeah, apology or apologetics is describing the way that international lawmakers and decision makers would reach a result that shores up a particular power move by a state with some understanding that a pragmatic view is necessary to preserving the international order. So the Security Council would be a great example of this. Why do we have the Security Council in the UN? The UN General Assembly makes sense, one state, one vote. Why do we have Security Council where these 5 random not random countries get to decide everything? That's apology. And even so, and the idea of sovereignty has both those aspects because it is expressing self-determination and kind of these ideals, but it also the definition of sovereignty in international law is premised in part on a very concrete analysis of do you have territorial control? Like, so, can you control your borders? That's one of the empirical determinations that is made in deciding whether or not any given territory has a claim to sovereignty. So that would also be a mode of apology in the sense that you're not building, the legitimacy of the state from a normative perspective or kind of political accountability or democracy. You're just saying, well, if you can control it, control people inside of the territory, then yeah, we'll recognize you. So that's the work that apology is doing inside of that kind of binary, if that makes sense. Does that make sense?
Yeah.
Right, I'm thinking of two cases recent, news recently. One is the Dominican Republic Haitian case. I think you're following that.
Yeah.
And the way that race
Expulsion of
reflects all of that.
Yeah.
And then the other piece that I thought of was the Dilma Rousseff position that the communications technologies of the U.S. violated technically, ability to manage a state sovereignty. That's just one example. So whether you're talking the Jones which you passed over the military power to violate somebody else's space, how does all of that fit? But I would love to, I know this is a work in progress, the DRA thing, but I wondered what you thought, how that fits into.
Well, I mean, I think the Haitian case is would be definitely an example of these dynamics. So just mass expulsion recently of Haitians, some of whom were, my understanding, second generation residents in the Dominican Republic, just invalidation of their
Citizenship to 1920.
their citizenship, going back to. So, is that a violation of international law? And as far as I know, there's no international limitation on how citizenship is determined. So you just have these different practices, ways of determining it, but it's a famously arbitrary or random phenomenon. So I think that would be a good example of international law kind of tinkering around the margins. So there probably were violations of international law in the way in which people were expelled. So the lack of due process, violation of right to family life. I'm sure those were violations, but the kind of central analysis of, does Dominican Republic get to just suddenly expel a whole population and say they're no longer citizens? I think that's I think that's a good example. And I think the communications technology one is good too. I have to think more about what I think about that. It's a good
Well, I
Yeah,
was
I
going to
think
ask
we're
a
out of
question, but it's okay.
time. Yeah.
Really,
Okay.
can I just make a comment? Because the issue of Israel and the occupation
Yeah.
is one thing that brings a lot of the dynamics
Yeah.
in one place. The right of return, occupation, and how occupation is justified within the logic of international law.
Yeah.
There is, of course, international law, there is the occupation,
Yeah.
right of protection of all those things,
Yeah.
and the right of resistance at the same time. So if you have just comment about it, because that seems to me like a complex situation by itself. For many of us as lay people, we don't know what the situation of the right of return within all of these things.
I think there's great work being done on this. We had somebody come last year, right? Omar Dejani came from McGeorge, who does, I said McGeorge, Dejani from McGeorge.
And also Honey.
And Hani also works on Palestinian questions. Omar's work really looks into the international law of self-determination and kind of what the claims would be to statehood for Palestine. And it's very good because it goes into the basically opposing modes of identifying sovereignty sovereignty, so kind of competing schools of analysis within international law that would have kind of differential impacts on whether you determine that Palestine has a bid to statehood or not. I mean, I think that's a really important example of all of these dynamics. I think it gets very complicated as well because there are just so many factors now going into the determination of statehood and what the basis of it would be. The territory of Palestine. Well, it has a lot of international recognition, not by the U.S., but by many other countries in the world now. The Palestinian Authority, after Oslo, was supposed to be a movement in the direction of this kind of control over territory. But many aspects of life in the Palestinian territories are completely out of the control of anybody within the Palestinian Authority. So trade over the borders, control of water, I mean, they're kind of very basic things that you would associate with government that Palestine doesn't have because of the occupation. So, does that mean that, occupation is, a kind of unjustified obstacle to legitimate claims to statehood? Or in an apologetic mode would we say, well, as a factual matter, the control over territory, people, government relations, and so on is in place. So I think, and this is where I sometimes get into trouble with kind of activists within international law, even though I am one myself. So actually tomorrow I'm going to go to a panel on drones and whether they're justified under international law. And the problem that I have is that it's very rare that I can actually say that some really bad thing that a government is doing is obviously a violation of international law, because very often there are good arguments under international law why the state can do this bad thing, and that's not an accident, because the power relationship is built in to the terms of international law and the way in which those terms are decided. So, yeah, and I think you could make arguments for and against, unfortunately, to state the question. But that's just such a partial answer.
We'll continue informally, but thank you so much.
Thank you so much for the great questions. So great.
Thanks a lot.
We just realized we are going to be on the
Yes, right, exactly.
For the Christmas craziness.
So you'll be doing.
But we just turned. Yeah. But legislation. Oh, okay, so we have the same. But it's decent. Yeah.
How are you?
All right, how are you?
Where's your
Yeah,
conference?
great.
How's your buddy doing? Zinnia, how's your buddy doing?
She's okay. Yeah. She's not bringing it. That's all about her. She's not trying to be organic, connected. You see, this is where it's all going.
Yeah, that's relief actually.
Do you want to give him a
Yeah, I think it's
head cover? You have the program? Yeah.
yes.
You have I don't know what else.
It's also not the
Well, there's not, it's just mine.
and then
I think that's they have
Okay, so
website for it. Yeah.
Okay. Can I just say one thing quickly?
Yeah.
There is a section.